regulated as criminal offences. And why do I say that? The regulations, of course, begin with the Basel Convention, and it is made quite clear through the European regulation that the primary focus is going to be on the protection of the environment. The Convention and the regulation recognise the tension that there is between the interests of industry and reuse and the protection of the environment, but it's made quite clear that the balance falls in favour of the protection of the environment. So the courts have recognised this. Wherever there is a grey area, the default position is going to be the one which provides the greater protection to the environment. And there's very much a theme in the regulations and in the Convention of using the stick to regulate this industry. There are other provisions. There's the take-back system. But from the Convention through the European regulation and into the British regulations, it is made quite clear that sanctions for failing to comply is the default position. So the Convention itself says each party shall take appropriate legal, administrative and other measures to implement and enforce the provisions of the Convention, including measures to prevent and punish conduct in contravention of the Convention. So a strong emphasis on treating illegal dumping and non-compliance as criminal, and the difficulty that arises is what happens when it falls into a grey area. It's in the EU regulation as well, Article 50, as it happens, of the shipment regulation. Member States shall lay down the rules on penalties applicable for infringement of the provisions of this regulation and shall take all measures necessary to ensure that they're implemented. The penalties provided for must be effective, proportionate and dissuasive. That's what English lawyers would call a call for deterrent sentencing. And you'll be hearing a little bit from Sam Riggs and Anna Willett about that. When it comes to our domestic regulation, that reflects it. Transfrontier Shipment of Waste Regulations 2007 creates 61 separate criminal offences for failing to comply. Compare that with the permitting regulations, which I think has just 5 offences, separate offences, set out within it. So within the shipment regulations, there are overarching requirements. So it's an offence to breach the overarching requirement, not to act in a way that's harmful to the environment or harmful to human health. But also each of those regulatory steps that you're required to take at notification, each of them is enforceable by way of criminal sanction. And then there are corresponding offences for importation of waste as well. So these regulations very much take a stick approach, just to emphasise the potential consequences of it. Directors, officers of the company, the directors, the managers, or if it's a partnership, the partners of the company can be held liable if there is any default. The test is whether there is any consent or connivance. So obviously if you knowingly allow your company to breach a regulation or you turn a blind eye to what your staff are doing, then you might be held liable. But you can be held liable as well as an officer of the company for neglect, failing to have technically competent people undertaking the work, failing to have within your organisation clear lines of responsibility, failing to have the resources provided to ensure compliance and access to proper legal advice, failing to provide management supervision. of what staff are doing, and ensuring that it's all written down so that if ever there is a query, you can demonstrate that you did what you could to avoid any mistake by your organisation. So, message to managers, directors, make sure that you know what your staff are doing and that it's well documented. Even your staff can be liable, or your subcontractors. Regulation 57 provides that third parties can be prosecuted as well, where there is fault by them, where they are the cause of a breach of the regulations. So you need to make sure that your employees are aware and your subcontractors that they would be held responsible if there was any breach. And the consequences: maximum penalty for an individual, a director, a manager, an employee, 2 years imprisonment or an unlimited fine. For a company, an unlimited fine, and also the possibility of confiscation of what are viewed as the proceeds of crime, the profits that the organisation may have made as a result of any offence. So that in outline is the risks that are there. What have we learnt since 2007 about the way in which the courts are going to approach cases of this kind? Well, the first thing that we've learnt is that there is potential liability all the way through the supply chain, from the point of our origin onwards. Court of Appeal in a case in 2011 dealing with waste electrical equipment said that export is a process commencing once the waste is destined for a country, for that country at its point of origin, and continuing until the waste reaches its ultimate destination in the foreign country. Prohibition must encompass all stages in the export shipment chain from the point of origin in the member state of dispatch onwards. That was a case that came before the court in Basildon. It involved operators not just in that local area but across the country who were involved in the collection of waste electrical equipment, much of it coming from civic amenity sites, that was then packaged up and placed in containers and was being shipped out to Nigeria. It began, in fact, with a very good bit of investigative journalism involving someone from Greenpeace and Sky News who took an old television set, totally disabled it so it was fit for nothing, and put a tracking device in it. They took it to a civic amenity site and watched and waited to see what would happen. And sure enough, it found its way eventually to Nigeria, where it ended up on a market there. And there was a broader investigation involving containers that were stopped in this country, others that were stopped in the Netherlands. And a number of people involved in the supply chain ended up before the court, various people at various stages. And the Court of Appeal made clear in that case that there would be responsibility at every stage of the chain, potentially from the point of origin onwards. And so at whatever stage your organisation has an involvement, you have to be aware that you are at risk. That case, in fact, came before the court more than once, before trial and also post-conviction. There was a further hearing in the Court of Appeal, this time in 2012, and it established the principle that ignorance under the 2007 regulations is no defence. Well, Justice Pitchford said, the obligation which the regulations place on the transporters is to take care to acquire knowledge of the cargoes they're transporting. If they do not, they take the risk of breach. It was emphasised in that case that you can be guilty of an offence under the 2007 regulations and you have an involvement even if you don't realise the goods that you are handling are destined for export. You can be held liable even if you do not know precisely what it is that is in the container. It's a very harsh rule, but the view the Court of Appeal took, interpreting the regulations and bearing in mind the primary purpose is to protect the environment, the Court of Appeal took the view that those who get involved in the shipment of waste do so with their eyes open. And it's a case of operator beware. If you involve yourself in the industry, ignorance will not be a defence. The third thing that we learn is that there are grey areas, and that's where difficulty can arise. Is it a waste or is it a product? And it's the point Adrian was making a little bit earlier. At what point does it cease to be waste and become something for reuse? That image, I think, does come from the Basildon case. In that case, the waste electrical equipment that was being exported largely had not been tested for fitness for purpose, although the defendants in that case claimed that what they were sending were second-hand goods, no longer wanted by UK customers, but enthusiastically required by people in Nigeria, something I'm sure Wayne would be, in a proper case, very enthusiastic about. That idea of reuse was at the heart of the defence. And so what the court had to consider was the material that was being exported at that stage still waste, or had something happened in the United Kingdom that meant it had ceased to be waste and had become effectively second-hand goods fit for purpose? To which the answer was no, for two reasons. On the facts of that case, there hadn't been a proper process of sorting and testing to make sure that what was going out was fit for purpose, so they failed on that count. And secondly, taking perhaps echoing something that Nikki had said in the theme of her talk, behind those television sets that you see there was just junk, very much in the way that drug importers operate, with cover loads of seemingly legitimate goods. Once those half-decent sets at the front of the container had been removed, what lay behind was just a massive cathode ray tubes that were hazardous waste, and it was all really a bit of a scam. But there are grey areas, and it's difficult to test. Some of you may have come across the Ideal Waste case as well, another prosecution, and a very difficult and thorny issue involving the export of recyclable paper. And you may hear with dismay the answer to the question, how do we find out whether it's still waste or whether it's now being treated as a product? The issue in that case was it still to be classed as household waste or paper that was suitable for recovery? And the answer of the Court of Appeal was it's for a jury to decide, because we have no other way of assessing it. To protect the environment, we have to have the ability to prosecute. And so in an appropriate case, it's got to go to court, it's got to go to trial, and a jury will have to decide and answer the question in our system, whether or not the offence had been committed. And the jury will be assisted by technical evidence. The jury, the Court of Appeal said, can look at photographs and they can decide for themselves, a matter of common sense at some levels, whether or not material is still household waste or whether there's been a sufficient process that it's become something different. And it's not a satisfactory, going off giving legal definitions there, you may think it's not a satisfactory way to deal with things. And life would be a lot better for you and for the courts, those of us involved in the legal system, to have clearer black and white definitions available to us as to when something is still mixed household waste or has moved on. I was in the High Court in Manchester just over a week ago dealing with a case involving enforcement proceedings against an operator who had ended up with about 40,000 tonnes of mixed waste on his site. The case has been going on for about 5 years, and 3 years ago he'd given an undertaking to the court to clean the site up. And he's spent over £1 million doing that. He's put a lot of effort into it. But in fact, we'd arrived at the position where the definition in the order as to what he was to do was to remove mixed non-inert waste. And he cleaned it up to what he thought was an appropriate standard, and that was supported by expert evidence. And the Environment Agency didn't think it was good enough. And the difficulty in that case was that there was a definition that was so grey that it became unenforceable. And we almost had to start again and rewrite a new definition as to the standard to which it had to be cleared up. So from a legal point of view, from a regulatory point of view, it is very important where we can to have clear definitions. One last thing to say in respect of the 2007 regulations, practical example. I advised in relation to a case in the Leeds Crown Court some years ago involving one of many defendants who'd come before the court. A similar sort of scenario to the Basildon case, a chain of supply. It began with a plastics manufacturer who had rejected various batches of plastic product, various offcuts being produced in great quantities, many tons of the material. And it gave rise to that same sort of problem. Defendants who took the view that what they were handling wasn't waste, it was a second grade product. It wasn't to the standard that was wanted by the customers in the United Kingdom, but it had a market elsewhere. And that came before the Leeds Crown Court, and following some legal argument, it was accepted by the defendants and they pleaded guilty, that really it had remained a waste, not least because there was quite a high level of external contamination on the plastic waste. So a number of people were involved in that, from manufacturer through to the actual shipping company at the end of the chain.